That's why preparing a very detailed First Amendment to the motion for a new trial, this is where it pays off. You get it, oh, I've got 13 days, big deal, I've already written it for the most part, I've just got to rearrange it, okay? There's nothing worse than getting a notice of docketing out there when you haven't done that. And you're pulling your hair out, scrambling to meet that deadline. So if you're ahead of it, it's not that bad. And lastly, at that point, they tell you that here are the deadlines, here's when you submit your brief, and they refer you to the Court of Appeals rules. And I'm not going to get detailed into what the brief should contain, because Chris already has, but I do want to make a couple practical suggestions. There is a great book called Making Your Case, The Art of Persuading Judges by Brian Garner and Antonin Scalia. I don't think I agree with Antonin Scalia on anything, but that is a wonderful book. It's become my Bible. And it splits the book into brief writing for appeal and oral argument. And I studied it. When I went up there to do the sex offender oral argument, I had read that book backwards and forwards. It's got some great, just practical suggestions for what works and what doesn't work. The other thing I would suggest is, you know, when you're doing a brief, you have to consider little details like what font to use for my computer. He discusses some of that. And there is the website of the U.S. Court of Appeals for the 7th Circuit has a link on there, and they have a little discussion about what fonts should be used, what fonts shouldn't be used. It's enormously helpful. All right, that's all.
14 times New Roman.
What'd you say?
14 point times New Roman.
Right. But that kind of stuff matters, and that book is great. You can get it at Barnes & Noble. And that website site from the 7th Circuit is tremendously helpful. Right.
I have just another one of those sort of nitpicky timing things. And you're mentioning how long it takes the Court of Appeals to send you mail. Reminded me. A lot of times at the very end of the case, when you're about to turn your case over to your client because you lost, which unfortunately we lose a lot. In the past, it would take, and I'm in DeKalb County, it would sometimes take me 6 days to get the denial. And then my client has 4 days to get a motion for reconsideration into the Court of Appeals or a notice of intent to seek cert. And then I'm feeling bad that I can't possibly get it to my client in prison in time, and then I find myself doing a pointless, frivolous motion, you know, or notice of intent to seek cert on my client's behalf. And I finally learned Westlaw, and probably Lexis does too, I don't know, but they have this function called alerts. And so what you can do is you can program it to run a search every day. And so I just program it to search for the case number, A10, A2345. And it just runs it every day quietly, but when it gets a hit, it emails me the opinion. So usually, like, I'm taking a shower in the morning, and I'm like, on my BlackBerry, like, oh, I just lost this case. And then I can send my client something days before I even receive it in the mail.
So, Jordan, let me ask you about that now. You're talking about technology, so I've got to ask questions. You mean you could do a Westlaw alert? For example, if you're waiting on an opinion from the Court of Appeals or Supreme Court, and you know it becomes maddening when you're getting close to when you expect the opinion because you check the website 7 times a day. But you don't have to do that with the alert. Is that what you're saying?
That's right. It'll run 3 times a day, I think. For some reason, it always finds them in the morning. And it takes, you know, you don't get it the same day. Westlaw doesn't get the opinion out until sometimes 2 days later, but usually 1 day later. And the Supreme Court, of course, they always come out Monday, and you can just check. But the Court of Appeals, the only way you find out is if it's in the mail or if it's on Westlaw. So I find that to be highly useful, because then I can just very quickly get that out to my client and let them take it from there, assuming I'm, you know, throwing in the towel at that point.
Okay, I'm gonna sit down. Ask Mr. Stubbs to come up while I get some more water.
I'm Tom Stubbs. Y'all are, a good bit of you, some of you seem to be too young to remember the Bullwinkle Show. They had a sub-cartoon within the Bullwinkle Show called Peabody. I think it was called Peabody. Mr. Peabody was in it anyway. At the end of that, it showed a parade and some guy just sweeping up down the, you know, I feel like that you've gotten pretty much what you need, and I'm going to just touch on a few small things, and then say something I shouldn't say at the end. Tradition I have.
Only one?
Yeah, I'm down with one. I'll start right there with that. I take that Westlaw alert to one other level. I have every morning appearing in my email box every new case issued by the Court of Appeals, the 11th Circuit, the Georgia Court of Appeals, and the Georgia Supreme Court. You want to become a great lawyer, don't follow my practice except for this one, and do that, because every morning you glance down these cases and you will see law issued and you'll catch all the new cases. One of the neat things is exactly what Gerald said. Folks don't get their own cases usually until way down the road. I can't tell you the number of people I've told the outcome of their case and they have said, what? It's great. You can email your friends, you see a case came up. The only problem is the early edition is hard to see the name of the lawyer actually on the case. When Westlaw first gets it, that's not included in the initial publication of the opinion. On their site, you have to take the case number, go back to the court, put in the case number, and you'll see who the attorneys are. But it's a great way to track issues. It's a great way to keep up with the law in general. And that will go to my second appeal, general appeal, give up the big firm law. I'm serious. I don't know how many of you went to school for what you're doing right now. If so, I don't mean in this room, but in your big firm. Congratulations, you found a great place to make a fortune and do some stuff. But I didn't. I wanted to make constitutional arguments. I went to law school because of the very things that I was not doing as an economist. I was an economist in a prior life. I graduate degree in economics and worked in the U.S. Senate. I came to law because of the rights of people that are beyond economics. In the back, we've heard, if you haven't been introduced to Jim Bonner, Jim is a participant in any number of legal forums. People write on emails on the listserv for criminal defense lawyers questions, and usually within 3 seconds there is a response back from Jim. You'll notice Jim has one arm. And I wrote him one time and I said, son of a bitch, how do you write that fast one arm? And he said, I make it up and nobody ever checks me. The fact is, he is part of the second part of what I'm going to talk about, and that is resources to help you in your appellate work. First, if you can swing it, just for the time that you're going to be doing this, and just because it's a phenomenal organization that warrants the support of everybody, I'm going to urge you to join the Georgia Association of Criminal Defense Lawyers, GACDL, G-A-C-D-L. When you do that, you'll also be eligible to join the listserv and see the daily musings, rantings, and amazing insights of attorneys across this state. And by the way, my father grew up in Scriven County. It is the teenage pregnancy capital of Georgia. There's not a whole lot to do there.
I have 5 kids, but I grew up in Savannah.
Big city. But you will get things like this. This is what's the decision publication they put out. But for me, really, that listserv is every day's CLE. It's like drinking water from a fire hose sometimes, but you'll find it to be a great resource and a place for you to go when you have questions, basic or advanced, about a judge, about a situation. You can get great help on everything. And about a third of the time, the answer will come from Jim Bonner. There are other organizations. The National Association of Criminal Defense Lawyers is also an excellent organization. You can get some beautiful, glossy publications from them. If you've got a lot of money and you want to join something, you can get that. They have a publication called The Champion, which makes for a very good reading. This stuff is actually inspiring for me. The American Bar Association, which I bet a lot of you are members of if you're in a big firm, they have a criminal justice, I call it their token criminal justice division, because they want to look like there's all things to all lawyers, but they're not. But they do have that, and they do have good articles in there. Second, they actually have fascinating articles. The appellate work. You've seen Chris McFadden. If you didn't know about his book, I saw a lot of you raise your hand. When you've done appellate work, you're going to want to consult his book. It's not just his book. There are others in it, but it's his book. There is another book, does take at some distance to suggest. This is the old edition of the book put together by King and Spalding lawyers, Chilton Farner and Sam Griffin. There's a chapter in there on preparing the record that I prepared, so you want to steer clear of that. but otherwise, it's a pretty good book too. Now let's take up just a few details in what was said before. Another reason for you to prepare the order yourself. I'm going to take a little bit of issue that the file date is what you have to pay attention to. He was talking about the file stamp date. That is normally the critical date. The judges can enter an order non-pro-tunc. Non-pro-tunc means it's got a retroactive date. And if you've got a son of a bitch judge who's pissed off and there's been a delay for some reason in the order being entered, he may enter it non-pro-tunc back a week or 2 weeks ago. And your time for appeal, your time for motions is measured by the effective date, which would be that earlier date, not the date that is filed, not the date that is signed, but if he's put a non-pro-tunc portion in the order, that's the date by which you have to watch to measure your calendar. So by preparing the order yourself, and that's the case of Ross versus State, 2003. I may have missed it, it's been overruled.
I think so. I sure hope so. I'm pretty sure it has.
It should be.
It greatly needed to be overruled, and I'm pretty sure it has been overruled. But the mistake might reappear. So as a cautionary thing, I would concur with the suggestion to try and get it in that date. But theoretically, if that's the law, a judge can reduce your appeal time to less than 0.
Has Ross versus State been overruled on that issue?
I think it has.
All right, thank you. Never mind.
I think it was, it
I've lived
finally
under
got
it.
to a case where a guy had been screwed out of his right to appeal by the
By the-
order. And it was really one of those things that, it was a mistake the Court of Appeals had made. It was just awful.
It's horrible ruling. Horrible ruling.
Yeah.
I'm glad they got it.
Well, I think I think the restriction is that it can't be used to deprive you of a right to appeal.
Good, because that's exactly what it does. That's kind of, in the civil context, that's sort of a Judge Andrews argument. He's ruled that you may lose your right to appeal an injury that you didn't know in the medical context when this comes up often. You didn't know you had it until after the time to file a claim has lapsed. He's a strong advocate of your SOL, bud. And that kind of thing does find voice in our Court of Appeals judges. One bad. Notice of appeal. You know this if you've done civil appellate work because it's the same thing. You have to be bizarrely redundant. Don't just say, I want to send everything up on appeal. Say it several times. I want to send everything up on appeal. If I've been in any way unclear, I mean to include everything. And if this is read to mean that anything may be omitted, that is not to be read that way. I mean to include everything. And then you go to another paragraph on the transcript. If you don't specifically mention the transcript in your notice of appeal and they fail to include it, you may have waived your right to have that in there. You need to say, and this includes specifically the transcript. The Georgia courts are, in some respects, so much friendlier at the Court of Appeals level than the 11th Circuit Court, where they have atomic consequences for things like this. You have a case go up there on briefs. It's not been a hearing at all. And there's a form you have to fill out for transcript requests. Well, you got no transcript. No need to request it, right? Wrong. If you don't file a form saying, I don't need a transcript, they will dismiss your appeal. Not that that's ever happened to me twice. Twice. A good friend of mine who, extraordinary criminal defense lawyer and well-renowned, and I were comparing one day how most of the job of the criminal defense lawyer is groveling. You grovel with the DAs, come on, he's a good guy, come on, let's do this. You grovel with the judge, come on, the sentencing. Groveling to the 11th Circuit is very difficult. They really don't let you in to grovel very easily, so but you can grovel and get back in. Next, we touched on the index, and I'm sure those of you who've been involved in appellate work know about this, but let's just make sure to cover it carefully. When you get the record going up on appeal, you have to refer to it in a certain way. And you need to, I usually end up going over to the Court of Appeals, getting a copy of, or having them send it to me, this index. They put things in according to boxes or according to certain binders. And you refer to parts of the record by virtue of where it is. So it'll be in volume 1, part two, and they're all paginated consecutively.